Hi, everyone. We're going to get started. First, if I could introduce myself, my name is Rick Vanderslice. I am a joint degree graduate of the class of 2001. I have the honor of being the Philadelphia area representative to the Vermont Law Alumni Association Board of Directors. I'd like to welcome you to today's event, which is presented by the VLSAA. Thank you all for joining us. Before I introduce today's moderator and panelists, I'd like to review a few housekeeping items with you. Please feel free to rename yourselves and add your degree and class year so that your fellow alumni can see who's participating today. To do so, please click on the three dots on the upper right-hand side of your Zoom tile. You'll have to move your cursor for it to appear. Once you do that, you can select the option that says rename and type in however you'd like to be identified. Also during the call or the Zoom, would ask that you mute yourself to ensure that we can hear all of our presenters without any distractions or background noise. There will be a brief or a question and answer period at the end. We would ask that you can unmute yourself for that, but please raise your hand with the raise your hand feature at the bottom of the Zoom to allow, so everyone's not talking over everyone at once. Lastly, if you could turn off your camera if you're not speaking, so as not to distract from the panel. Feel free to enter your questions or comments in the chat feature on the right-hand side. To access the chat feature, you just go to the bottom again. It'll reveal itself once you move your cursor and click on the chat to everyone or directly to panelists. It will be moderated and curated by people at the OARD, Brock Monroe, and Laura Close. Before I give the floor over to our presenter, I'd like to share a quick overview of today's event. I'm joined by three other VLS alumni, all of whom are leaders in the regulation of the burgeoning cannabis industry. To start us off, you'll hear from Christopher Smith, who's a JD from 2014 and is currently the Associate General Counsel for the Massachusetts Cannabis Control Commission. He'll give us a 10,000-foot overview of the national landscape of cannabis law. Then we'll transition to a panel discussion, which will be moderated by Kyle Harris, who is a joint degree from 2015. He serves as the commissioner for the Vermont Cannabis Control Board. Last but not least, Laura Bianchi, who graduated with a Juris Doctor in 2008. She is the founding partner of Bianchi and Brandt and one of the nation's foremost experts in cannabis law, compliance, operations. And Christopher Smith will also serve as a panelist. Finally, we'll conclude the event with a question and answer period. It's now my pleasure to introduce Christopher Smith. As the Associate General Counsel for the Massachusetts Cannabis Control Commission, where he advises the commission on legal matters in settled and evolving areas of cannabis law, Christopher served also as a contributing author for the Cannabis Law Desk Book. That was published by Thomson Reuters in 2021. Christopher previously practiced in corporate law in the private sector, and before that, served as director of the capital markets for the Vermont Department of Financial Regulations. Prior to attending VLS, Christopher worked for almost a decade at Starbucks, where he opened dozens of stores throughout New England. Christopher is also the past president and a board member of the VLSAA. With that, I turn it over to Christopher. Take it away.
Thank you, Rick. I appreciate that introduction. I'm going to share my screen really quick, so hopefully that is going to work. If I could get essentially a thumbs up, if that has worked, awesome. Thank you, Kyle. So my name is Christopher Smith, and I'm going to give us sort of a 20,000 or 10,000 foot view of what cannabis law looks like across the country. Like any good lawyer, I'm going to start with some disclosures. So first, everything I'll talk about in the next 10 minutes or so is going to be very cursory. I'm going to fight against every pedantic bone in my body. So if you're familiar with these topics, know that I know that this is cursory. And if you're not familiar with these topics, know that there's a lot more detail involved. I'm also going to use the word cannabis rather than marijuana. Cannabis is the proper name for the plant. There is a legal fiction distinguishing between hemp and, quote, marijuana. Marijuana being when it has matured to a point of having 0.3% THC or more. But marijuana in the US has somewhat of a pejorative history. So I will stick to cannabis, but I am referring to what is under the law marijuana, call it weed, pot, whatever you want to call it. I will note that anything I express are my views and do not represent any position of the Massachusetts Cannabis Control Commission or the Attorney General's Alliance. And finally, I'd like to note that when I think about cannabis law, I often think about Justice Brandeis's dissenting opinion in New State Ice Company, where he describes states as laboratories. And really what's happening across the country is many states are engaged in a joint and several experiment. And some of what we discussed today will really be the early results of those experiments. So cannabis across the country has had a journey over the past decades. Most states and the federal government had a history of straight prohibition, making it a criminal offense. Some states had moved to decriminalizing cannabis, making it more of a civil offense to possess or use. In the 1990s, California led the way by establishing medical use cannabis under its laws. And more recently, more and more states have begun to adopt adult use or recreational tax and regulate schemes. Most of those were done by popular ballot initiative, but a growing number of states are doing so through legislation. I do have a small asterisk next to South Dakota because South Dakota had passed ballot initiatives to amend its constitution to pave the way for cannabis. However, those were struck down due to procedural issues. Recently, I saw a news article, though, that advocates have gathered sufficient signatures to get it back on the ballot, and they're hoping, obviously, to pass that without the procedural issues. So take a look at what that looks like nationally on a map. The dark green states are those that have both adult use and medical use cannabis, and the light green states are those that have just medical use. Gray states being those that do not have legal, medical, or adult use of cannabis. And I'll pause right here on this map just so people can take it in for just a second. And of course, as states have more and more adopted adult use cannabis, there have been various policy objectives that were stated as to why they adopted these programs, but there are a few that are pretty consistent across many states. The first being sort of a libertarian individual freedom perspective for the individual right to, for personal use, possession, and cultivation if you're over the age of 21. A big motivating factor was definitely tax revenue, and states have varied in how they tax cannabis, whether it's retail, an excise tax, and or a wholesale tax, but state taxes vary from 5.6% to 38% depending on the state. Local taxes also are allowed under certain states where those municipalities or county governments can add an additional tax on cannabis within their borders, and those can vary from 2 to 7%. One of the goals of tax and regulate programs is to replace the legacy market, or what was previously the illicit market, and transition that from contraband status to the regulated status. And states have varying success with that goal. And finally, a lot of states, as they adopted adult use cannabis, have also included equity initiatives, which serve sort of two purposes. The first being reconciliation, if you will, for the disproportionate harm caused by disproportionate enforcement of the war on drugs. And equity initiatives also serve the purpose of ensuring a diverse, equitable, and inclusive market for adult use cannabis. So as states are adopting their various programs, they have to deal with that administrative law aspect. And so it's kind of that basic administrative law question of who has the authority and what is that authority? And in this area, states vary as well. Some states like Massachusetts and Vermont created a new agency. to deal with tax and regulate schemes. Some states like Connecticut expanded the authority of an existing agency. And then some states, have concurrent jurisdiction where authority is split over multiple agencies. For example, in Illinois, the Department of Agriculture has authority over really, cultivation and product manufacturing, and the retail is with the the Department of Business Regulation. And with this authority that is granted to these regulatory bodies, they get the authority to go through what is traditionally known as the administrative process, right? So they have the authority to promulgate regulations. Some of that is mandatory. You must pass regulations that deal with packaging and labeling, for example. But they also sometimes get that discretionary authority, which I kind of think of as the necessary and proper authority to pass regulations in order to fulfill their statutory mandate. Once those regulations are promulgated, of course, they have to enforce them through inspections or examinations of various types. And if folks do not follow the regulations, those agencies can then in turn take enforcement action. When there is a dispute about whether or not regulations are being complied with, that often also goes through an administrative hearing process or an adjudication. So those agencies also often have that authority. Now, all of this is happening at the state level. In addition, I'm getting ahead of myself. In addition to this authority and the policy objectives, many states have sought to control market composition of adult use markets, and they've done this in a variety of ways. Licensing caps, so for example, in Massachusetts, you cannot have more than 3 of any type of license, except for a delivery license, in which case you're only allowed 2. Some states have dealt with vertical integration differently. So vertical integration being where the supply chain is housed all within the same company. Some states require vertical integration as a consumer protection measure to eliminate sort of the markup that happens throughout the supply chain, or to really be able to trace that supply chain more easily. But on the other end of the spectrum, some states prohibit vertical integration because vertical integration can rise to the level of being an antitrust violation. And then, of course, there are the states in the middle that are either silent or just allow vertical integration to some extent, but states sort of are looking at that factor of market composition. Another key factor is suitability. Folks often who want to participate in the adult use markets have to demonstrate that they are suitable to do so. And so they usually go through a background check, and certain offenses or criminal history would deem you unsuitable, and therefore you would potentially pose a danger to consumers if you were able to participate in the market. I already mentioned equity programs, but that pops up in market composition as well. Sometimes that's accomplished through funding or helping certain businesses establish capital, but it also can result in licensing preferences for folks to get through the licensing process to make that a little bit easier for them. And then finally, some states have established what I refer to as residency requirements. So either requiring that in order to participate in the market or part of the market, you have to be a resident of a given state. But also states have also established preference in licensing processes for residents of the state compared to non-residents. So all of this is happening at the state level, but it really is in the context of federal prohibition. The Controlled Substances Act makes it a federal crime to use, possess, manufacture, or sell Schedule I drugs, which includes cannabis, or in the law, it's called marijuana. But despite the Controlled Substances Act and that federal prohibition, the federal government in various ways have created space for state legalization programs, namely in the form of the Cole Memorandum, which was in effect from 2013 to 2018, which really just established Department of Justice priorities for enforcement of the CSA with respect to state programs. That was repealed in 2018, but AG Garland has indicated that the spirit of the Cole Memorandum is still somewhat alive. And then there's also the Ruerbacher Amendment, originally the Ruerbacher Amendment, now the Ruerbacher-Blumenauer Amendment, which is an appropriations amendment that says that the Department of Justice cannot use its appropriated funds to interfere with state medical programs. So that's just medical. It doesn't provide any protection for adult, but again, it's a federal government sort of head nod toward these state programs. And finally, I'll note, which I think becomes important and has become important recently, that the Supreme Court of the United States in 2005 did hold that the Controlled Substances Act is a valid use of Commerce Clause authority because it is trying to eliminate cannabis. And so it does reach purely intrastate, non-commercial medical use of cannabis, even when it's legal under state law. That has led to many challenges to residency requirements under the Dormant Commerce Clause. So across the country, folks are challenging residency requirements, saying that they're discriminatory, and whether it's a result of a merits decision or just a defendant choosing not to enforce the residency requirements, we're seeing residency requirements being eliminated as a result of Dormant Commerce Clause litigation. There's also questions about the Supremacy Clause and preemption, especially in the context of workers' compensation. Several state Supreme Courts have ruled one way or the other as to whether the Controlled Substances Act preempts state workers' comp laws that require the reimbursement of medical cannabis. And so there are two companion cases out of Minnesota that are currently being considered by SCOTUS for cert. Decision has not been made. They're actually waiting for the Solicitor General to provide input, but an interesting legal question that is fomenting at the moment. And finally, bankruptcy is a really big issue that arises as a result of federal prohibition. Bankruptcy becomes unavailable if the proceeds for the bankruptcy plan are derived from cannabis activities. And that recently included a Chapter 13 applicant who was an individual seeking to sort of restructure their personal finances, but because their W-2 wages were from a cannabis business, they could not avail themselves of bankruptcy. So that's pushing a lot of legal issues relating to financially distressed businesses or individuals to state court receivership or guardianship or conservatorship type proceedings, which is not usually where those people go or those businesses go, but it's creating that the lack of availability of bankruptcy has created this new heating up of state-based receivership. So in addition to federal law, as states have adopted their cannabis programs, they have to also think about local law, especially depending on whether they're a home rule state or a Dillon's rule state. Home rule states say that under the state constitution, municipalities and local governments have inherent authority, and under Dillon's rule states, those local governments only have the authority explicitly given to them by the legislature. So in crafting cannabis laws, states have to think one way or the other about local governments. And generally speaking, local governments do have that zoning and land use authority to determine the time, place, and manner that businesses operate, including things like buffer zones, can't be within so many feet of a school or a park. They can also limit the types of businesses that can operate in their city or town. For example, some towns completely restrict social consumption or restrict where social consumption businesses can operate. And some cities and towns have used this zoning and land use authority to limit the number of businesses of various types that conduct cannabis activities, including some where there are complete local bans. So what I think of as the pot version of dry towns. And so that's my 10,000 foot view of the cannabis landscape across the country. I thought I would end with this map once again, just because it does give that visualization of where it stands across the country. And with that, I am going to hand it over to Kyle. Kyle is a member of the Vermont Cannabis Control Board. He is a graduate of Vermont Law School with a Juris Doctor and Master of Environmental Law and Policy in the class of 2014. Prior to joining the Cannabis Control Board in Vermont, Kyle worked in agricultural development, focusing on emerging issues and economic development for the Vermont Agency of Agriculture, Food, and Markets. Before that, Kyle served as Associate Counsel for Environmental Affairs at the Corn Refiners Association in Washington, D.C. And Kyle has a Bachelor of Arts degree from the College of Charleston in South Carolina. With that, Kyle, I'll turn it over to you.
Thank you so much, Christopher. And what a great overview. That's exactly the ball of yarn that I and my colleagues, my fellow board members, have been trying to untangle for the last year or so. And there's just cannabis touches every part of the law. It's pretty incredible when you really think about it. But it's a really exciting time for the Vermont Cannabis Control Board. We're on the precipice of starting to issue licenses. I think we'll likely be issuing some cultivator licenses to some social equity applicants starting next week, if the rest of this week goes according to plan, but we've been taking it week by week. I want to back up though and just talk about how we got to this point and spend just a minute or two doing so before we really dive into some of the substance that Christopher referenced in his presentation, some of the overarching themes that really have been teased out through this state laboratory process, as Christopher alluded to. So Vermont cannabis was legalized through legislative action, as Christopher referenced, in the fall of 2020. And the Cannabis Control Board was seated in the spring of 2021. I have two fellow board members. James Pepper is the chair. He is a fellow Swan. I think he graduated in the class of 2014. I'm sure, Christopher, you could correct me if I'm wrong there. He's a fantastic leader for the board. And, that was only a year ago. We've made an incredible amount of progress since then. But what I can say is we spent the first couple months before we even started writing regulations to kind of interpret Act 164 of 2020, which is our legislative vehicle, understanding the landscape and the legacy market, as Christopher alluded to. But it wasn't limited to just understanding where we are now in this state as it relates to cannabis. It's understanding all of the players when it comes to all of the interests with trying to regulate something that's still, a hot topic, and that there's folks out there that don't see value in regulating cannabis, and they're entitled to that opinion. But we wanted to include a lot of their thoughts into our regulations because youth prevention is something that we take pretty seriously here at the Cannabis Control Board. So we talk to legacy growers, folks that are operating under the Agency of Agriculture's hemp program. We talk to the prevention community. We've talked to the League of Cities and Towns and our municipal partners. We are a deal in state, as Christopher went into a brief overview in his in his presentation. And so we really spent the first couple months really just trying to understand all of the vested interests that are present in Vermont. We started writing regulations about between Thanksgiving and Christmas. We have 5 rules that govern our market, and I think we did a pretty good job. And one of the main reasons that we were able to do and have those rules finalized so quickly is the amount of public participation that we included on the front end. Through all of our conversations, we've had over 400 public comments submitted to the board as part of our rulemaking process. We had 55 public meetings of the full board. We had an advisory committee, which is made up of multiple members in other state agencies appointed by the governor or the treasurer, and so on and so forth. We divided that advisory committee into subcommittees, given their expertise, had 70 subcommittee meetings all open to the public. And so all the work that we did at the front end before we actually started putting pen to paper allowed us to move through the administrative legal process a little bit more expeditiously. Right now, we're in that suitability portion of Christopher's overview. We're making sure that, one, we can implement the rules that we wrote, and also make sure that we're getting qualified applicants and going through their applications with a fine-tooth comb to make sure that they're giving us everything they need to do, and they're passing their background checks and getting permits from other agency partners around the state of Vermont, whether it's fire safety or the Agency of Natural Resources, or ensuring that they've talked to their municipality to make sure that their municipality knows that they intend to operate a cannabis business in and around the state. So again, I don't want to spend too much time on the Vermont side of cannabis. I'm sure there's some folks here that are just interested in what's going on in Vermont. We're really close. We're expected to open retail shops in October of this year. There is an opportunity for the current medical dispensaries to open their doors sooner than that. We haven't had any full complete applications come through where we're ready to hand out a license to any of those current medical dispensaries. So if you're in Vermont this summer, there could be a handful of shops open. The full market will open October 1st of this year, and we're still on track to meet that deadline. And it's really exciting. We've got an incredible staff that's working hard. There's only 4 full-time staff in addition to the board. So I think we're really, which is crazy if you think about all of the everything that we've got to accomplish. But you know, I'm proud of our work to date. Before jumping into our panel discussion, I want to introduce our final panelist, Lauren Bianchi. Laura began her work in the discipline of cannabis law with the 2010 passage of Arizona's medical marijuana program. She was among the first business corporate transaction attorneys in the country to specialize in the nascent legal cannabis market and has represented clients in more than $200 million in transactions throughout the industry. As a passionate and powerful advocate for the development of a professional and responsible cannabis industry, Laura was honored by AZ Big Media as one of Arizona's top 100 lawyers, and she has also been recognized in Authority Magazine's Women Leaders of the Cannabis Industry. Laura also serves as a cannabis expert in numerous media outlets across the country. With that, let's move to the panel discussion. And Christopher, I'm gonna toss the first question your way because I saw in your overview how heavily focused and through a package deal, the issue of social equity really has come to a head in just about every jurisdiction across the country. So why don't we start with just that? How does social equity play into cannabis law? You referenced the Dormant Commerce Clause. That's something that we considered substantially when we kind of wrote in how you can qualify as a social equity applicant in addition to other parts of our social equity program. But I'm gonna kick it over to you to answer first before we hear from Laura.
Yeah, and like you said, social equity has almost been like a hand-in-hand type aspect of legalizing at least adult use cannabis. And the motivation is often that as is very proven out that the Controlled Substances Act or the state corresponding laws that created prohibition for cannabis were disproportionately enforced against people of color and low-income communities, and that has prompted sort of almost this reconciliation approach of establishing as you change the legal status of this product that someone was previously incarcerated for, you've got to kind of recognize the harm that was caused to them, their family, and their community by virtue of removing them almost as an economic actor from those spaces and working to get them those folks or folks who are in those communities or in those families a bite of the apple in these adult use markets. And they take different approaches across the state, and I'm not familiar with all of them, but priority application or expedited applications, funds to help folks capitalize, or ways in which other sort of support or technical assistance comes in. I think it's, I love that you all are thinking about the Dormant Commerce Clause aspect, because one way that folks are accomplishing social equity is limiting its availability only to folks within the state, which, depending on what the program looks like, could trigger those DCC questions. We've also seen where race is too much of a factor. In Ohio, an equity element of the licensing process was struck down because essentially race had operated as a determining factor. So it could not be, it was essentially struck down. But like you said, it's designed to really make sure that folks are getting into the market. And we see across sectors, not just in cannabis, but across sectors, low-income communities and communities of color have a hard time accessing capital, have a hard time getting real estate, and so as a result, have a hard time entering into the market. And so social equity programs generally seek to, I think, remedy some of those hurdles, and in particular because of the additional hurdles created by the disproportionate enforcement of the war on drugs. So I'll leave it there and kick it over to the other two panelists to address as well.
Sure, thank you. So, I think another important component of it that a lot of people forget is the expungement side of it as well, which was huge in Arizona. We just had the ability to set aside convictions, which when it came to our cannabis program wasn't sufficient. So a lot of folks who may not have had, the money, the parents, the folks to take these things that happened to them when they were younger and they follow them through life. And it means that you can't be involved in this industry in any capacity because most states have some sort of, agent card, things like that you've got to go through. And so, we worked with our regulators here. We worked in a number of states. It's a challenge. Regulators are afraid of being sued. We understand that. And the question also becomes once we put expungement in place, once these licenses are allocated, how do we then accomplish overcoming the other hurdles that come that programs really oftentimes don't address, which, as Christopher just said, capital, real estate, this is an expensive industry. It regardless of what you say, it's an expensive industry. And so getting the license is just one step. The zoning process itself can be hundreds of thousands of dollars. And so it's also bringing together the industry, but individuals from different types of businesses as the cannabis industry becomes more mainstream, as we call it, right? Who want to be involved in the industry and saying, hey, we need all of those individuals, all of that expertise to actually make social equity licenses really have the long-term and sort of global effect that we want them to have. And so it's the first really hard part is, of course, writing the program and figuring out what that looks like. No one is ever happy. But then once they're allocated, it's going, okay, what can we do with what we have, right? To actually bring in from the, a lot of times from the charitable, commercial, business sector and say, how do we take things to the next level and actually allow these people to become operational and really participate in the cannabis industry?
Yeah, I 100% agree. And from my view as a regulator, we provide multiple different pathways into our social equity program. There's a pathway if you're a Black or Hispanic American. There's a pathway if you've been incarcerated for a cannabis-related offense, or if your nuclear family has been convicted of or incarcerated from a cannabis-related offense. And when I say nuclear family, that's really up to the applicant to explain to us the nuclear portion of that. It can be a grandparent, a stepchild, an aunt or an uncle, depending on how it has impacted you. And we've also created a completely separate pathway that's a little bit more out in the ether. Are you from a community that's been disproportionately impacted by the war on drugs? And that's a little bit more subjective. And we've got a process to handle how we review folks that are trying to enter through that pathway. We also don't have a strict residency requirement. We ask that you're a resident of the state of Vermont at the time of which you're applying, but you don't need to have been here for a couple years. Other states do it for a year, 2 years, 3 years. And that's where we kind of really, as a state regulator, we anticipate to get sued over something. It's deciding where we think we have the best legally defensible path forward, especially as something as important as our social equity program. It kind of lends me to one of the next questions that I want to ask the two of you, and that's how different states handle ownership and control limitations. I can say we allow vertical integration in Vermont, but you can only have one type of each license, meaning you can have one cultivator license, you can have one manufacturing license, one wholesale license, one retail license, except for testing laboratories, because we're aware of that being a potential bottleneck. You can have multiple testing laboratory licenses. And so there's not really an ability to franchise here. Laura, I'm going to start with you. I'd expect your role as a practitioner in Arizona, but in likely other jurisdictions, you've really had to make sure you understand some of these limitations and how to maneuver through the application process as transparently as you can, considering.
It's challenging. It's also job security, which is a good thing. But, I think when we step back and look that 36 states, right, plus Washington, D.C. have some sort of medical program, and 18 states plus D.C. have some sort of adult use program. And every single one of those programs is different. We don't have consistency from state to state. We have quite a few long-term clients, so we work throughout the United States with them. And, it is complicated. It adds to the cost. It adds to the expense. You'll have some states who have it, just as simple as their inventory tracking and control systems, or a certain program is required by the states. Arizona doesn't have that. A lot of other states don't. And so you could have, even with a vertically integrated system, I could have the cultivation use one program, dispensary use another, for accounting and financial purposes another, and then the regulators, are trying to piece that together. And so it's challenging. Oftentimes it gives some of the bigger guys a little bit of a leg up because they have the financial wherewithal to develop their own programs a lot of times, or really figure out how to make that smooth and consistent, because it is challenging. And then you add the federal illegality to it. There's constantly a question about sort of this chicken and the egg, right? In Arizona, we had a battle about whether seeds was part of the plant. And it was like, well, how do you think everything got here? By immaculate conception? Like, did we just suddenly just a plant sprung? So, it's very difficult. The seed to sale tracking idea of things is wonderful, but it can be challenging in business practice. And so, it requires quite a few different areas of expertise. It requires individuals to have directors of compliance, teams of compliance. The software is constantly evolving. I would say, as someone who has worked with quite a few of them, none of them are perfect. They all have sort of the areas that they are that they're sort of geared towards, and then there's a lot of other things that are sort of left. And so we're constantly trying to fill in the gaps, which allows for human errors and problems and things like that. Regulators, again, do the very best, and we have fantastic regulators and good relationships with them. But oftentimes this industry has advanced really over 26 years. You've gone from one state, again, to the number I just explained. So the advancement in just the science behind it, the equipment, the sophistication, it's constantly changing. And so it can be really challenging to keep up from a rulemaking perspective on where we're at from an inventory tracking and control perspective when they don't totally understand that, a lot of us don't, as it seems to continue and the evolution really grows and expands. And so it makes it so that it's never boring, but it also causes, from a business perspective, it's something that you really have to work to keep your arms around.
And in addition to like ownership and control of the actual product, there's also a lot of requirements that, the ownership of the equity in the business is limited, or who has control to make decisions about day-to-day operations of the business. And that also creates some murky waters for practitioners to work in. The number of calls we get at the commission just being like, is this, is a cash sweep ownership and control? Is, what are these different organizational structures? And if you're limited, say, to one license, right, you can't, and you own 10% of that business, it becomes a question of owning 10% of this business limits me from owning anything in this other business, et cetera. And in Massachusetts, I'm using 10%. That's our threshold for being an owner, in which you have ownership or control over a license. And so it does create a lot of murkiness. And as a regulator, I often advise my colleagues that it does not matter what we put down on paper in regulation or guidance. As soon as we do, really skilled, thoughtful lawyers are going to create new organizational and ownership structures in order to either have to avoid registration or, whatever it is. But as Laura was saying, it's a fast evolving area, and we just continue to see these creative solutions to what is essentially a requirement. And even we sometimes find ourselves doing our facts and circumstances analysis as to whether a given person or company owns or controls another. And it's hard sometimes to say, and it's really a policy call, which can, be a struggle. And fortunately, as AGC, I don't have to make policy calls. That's for the board members and the commissioners to do.
Or get sent next door to litigation, more often than not. That's probably the number one area of disputes, is ownership and control of the license. So it's a constant question.
No, absolutely. And as my role as a policy setter, as a board member, and someone who helped substantially in developing our rules, we're certainly aware of creativity in this ever expanding industry, and industry is moving faster than regulation constantly is. That's not, strictly tied to the cannabis industry. That's everywhere. But, what we did is, or at least I believe we did, is from a ownership and control perspective, we're very clear in our rules on what defines, certain things. I don't want to get too far off track. But, we built in a lot of flexibility into our rulemaking so that we can respond accordingly if we need to, without having to trigger, the rulemaking process. So something, not necessarily guidance, but has the force of regulation and doing things through, policy making and so on and so forth. I want to switch gears a little bit and talk a little bit about a different aspect of of the cannabis industry. There's a lot of, proponents of cannabis out there that explain or, exclaim that its benefits, whether they should or not, from a health perspective, whether how it can help from an environmental perspective. Depending on when and where it's grown, especially outdoor grows and working as, buffer zones. And that's more in the hemp context, but there is some research coming out on how this plant can be helpful to the environment. But there is a lot of environmental impact that's not necessarily a good thing. I know that there's a lot of CAE grown cannabis around the country that is not getting good glowing reviews about its environmental footprint, depending on different grow methodologies. So Christopher, I was going to ask you this question first, if you wouldn't mind sharing your perspective on the environmental impact of the cannabis industry, maybe in Massachusetts, and as from your role as an assistant attorney for the Cannabis Control Commission, how you look to other states with respect to handling the environmental impact of cannabis.
Yeah, it is, especially being up here in the Northeast, right? We have a limited cultivation period. And in order to grow the supply for the market, there's a lot of indoor cultivation, which is heavy, intense energy usage, right, for those grow lights to make up for the lack of sun for most of the year. So we are seeing a lot of that. We see a little bit less of the water impacts here in the Northeast, but again, water impacts for other states where water is not quite as available of a resource is an issue. In Massachusetts, we have a very clear approach to most of our policy issues. As you indicated, regulation is kind of behind the industry always in every sector. But what we've decided to do is take a data-driven approach. And so the first step we took was that cultivators needed to report their usage of various resources. And then we're going to take that, analyze it, and then in the future develop policy around it, because we felt from the start, and I say we like I was part of the decision, I just work here, but the commission felt at the start that there wasn't enough information to really start putting strict parameters on it. But we do have aspects of our regulations that encourage the use of renewable energy and things like that, and our investigators do inspect for those things. So it is definitely a concern. In Massachusetts, unfortunately, we haven't been able to get ahead of it, but we are looking to kind of collect the information and data in order to make informed decisions about it. One interesting thing that I keep coming around to in my brain is obviously because marijuana is not an agricultural product, you cannot use pesticides or other sort of growth inhibitors or growth enhancers. So that actually resolves some of the water runoff issues. However, now that hemp is an agricultural product, to the extent that needs sort of these additives or pesticides, there's the concern of runoff water. In Massachusetts, we don't regulate hemp. That's with the Department of Agriculture. So we don't really have to deal with that. But there are states like Michigan and California that recently established or recently had one agency that oversees the entire plant, including hemp. So I'm interested to see what those agencies do in order to kind of bring a streamlined approach to the environmental impacts across the plant throughout its life cycle.
Laura, Christopher had mentioned water issues. I would imagine, just being in Arizona, that might be at the top of your list in addition to everything else. So maybe if you wouldn't mind commenting on that. And then I know, as we all alluded to at the beginning of this, we could talk about this for hours, and we're already running into what we set aside for question and answer. I had a couple more good bullet points, I think, for us to have a conversation about. But after you answer, let's move to some Q&A and kind of see what's thrown at us.
And Christopher did a great job. I won't take too much. It is we are absolutely not in front of it. There are issues with indoor, there are issues with outdoor, there are issues with the extraction process. It is something that I'm hopeful that between the regulators, the business themselves, and really, again, that evolution and sophistication of equipment and different types of ways to grow marijuana as we continue to evolve. Our goal is to keep addressing these things, but certainly in a few seconds or even in a few hours, I don't have a good, there's no good answer right now, unfortunately.
No worries. I get it. So it is 4:46. We wanted to set aside at least 15 minutes for question and answers for everybody who was able to join us today. We do have a question in the chat, and it's from Matt Trappini, fellow 2015 alum. I believe this is directed to you, Christopher. Matt's interested to hear about the environmental impacts that result from the enforcement regime requiring sealed packaging in the Commonwealth. It seems there is a ton of waste associated with current regulation.
Absolutely. That was a balancing question I think commissioners dealt with of, do we make more reusable type, a more sustainable packaging versus requiring the child safety aspects of it, and all of the labeling requirements and testing requirements. There's a lot of information that the state requires to be printed on the packaging and labeling of products. And so it does to some extent require almost new packaging. I will note that while our regulations do have those requirements, we have seen in the industry folks doing things like creating more reusable or recyclable packaging that either can be recycled or can be returned to the store for them to then strip the label. So like little glass jars rather than little disposable plastic jars, things like that are, child sealed tops. But you do definitely see like little, almost like I want to call them plastic bags, but they're not plastic bags. They're a different plastic material, but they're pouches that have like sort of a weird opening mechanism in order to make sure, again, it's to make sure children can't access these things just because they're sitting on a counter, if they're not being supervised adequately. But absolutely a valid point, and something we do think about at the commission, because we are considering those environmental impacts. But the decision was made at the commission level that those non-diversion type considerations were the top priority.
Yeah, and I can say in Vermont, we've taken a slightly different approach. And this is kind of where, getting back to Christopher's states are the laboratories kind of perspective in Vermont, kind of coming behind a bunch of different states to kind of see how we might be able to do things a little bit differently. But it still hinges on a couple of different things, because it looks like the Vermont state legislature is going to do away with CR requirements, child resistance packaging requirements for flour. There's a school of science out there that, if a child consumes flour, not concentrates, not edibles, but just flour, because that THC hasn't been carboxylated, it's not necessary. You're not going to get any psychoactive effect from it. So I think that we're going to move in a direction where we don't need CR for flour products, which moves us into a completely different world as it relates to packaging. The interesting part from my perspective is that a lot of packaging in the cannabis industry is kind of moving towards a bio-based plastic kind of alternative to petroleum-based plastics. I used to work with bioplastics when I was in DC, but one of the issues that we faced in Vermont in trying to determine what products would be suitable for retail establishments is there's no composters in Vermont willing to take bioplastics right now, and there's one operating landfill in the state. So how do we look to reduce waste? We decided to ban plastic altogether from a retail perspective, which is a little bit different and bold. And I've had packagers kind of pound the table at me in frustration because they've tried to move the industry in a direction that doesn't work for Vermont. But that's just my 2 cents. It's it's a different world up here than it is in Massachusetts. Laura, I didn't know if you had anything to add.
Yeah, again, as our programs evolve, unfortunately, I think regulators have to contend with sort of the order of priority. And so for a lot of folks, especially since we just really adopted our adult use program, for a lot of people, it was security, it was diversion, it was keeping it away from kids. And so, I feel like I keep saying the same thing, but as the industry evolves, we're certainly taking it in baby steps. And like I said, in 26 years, we've come a long way, but I feel like now that we're sort of settling in and all those horrible things that they said was going to happen didn't, or children haven't, all become meth heads and all those things. Now we can really start to look at the operational and the impact of the industry. And so you're starting to see that more and more in the West, but I feel like we're still a little bit behind because we're still addressing some of those fears and concerns that are out there. And when they're trying to get a program passed or we're trying to get that implemented, there's, the order of priority a lot of times shifts more towards security and diversion and protection for kids.
Yeah, absolutely. And we've tried to find ways in Vermont that kind of will make this kind of program look and feel like what Vermonters value, which is small batch, high quality products. But we need to stay true to the Cole memo, as Christopher alluded to, and those 8 priorities outlined in the Cole memo to make sure that Vermont is not prioritized for DOJ and FBI enforcement. But we're figuring out ways to kind of, move the industry, at least from our perspective, forward in a way that's environmentally friendly, and some other stuff that, we can talk about at a different time that we're attempting to do here that look a little differently. We do have another question, and this is actually a great question because it was on my bulleted list for panel discussion that, we never got to. This question is from Jeremy T. Berry. And his question is, my practice is focused on real estate finance, which inevitably has a federal aspect. Given the regulations with which banks and lenders must comply, this causes issues with lending to cannabis-related businesses. Do you see any ability for lenders to provide financing to these businesses before federal regulations catch up to the growing nationally consensus on cannabis? Laura, Christopher, I'll let you both decide who wants to take the first crack at that, because I would expect that you have two different perspectives based off of your role as a practitioner and as a general counsel.
So certainly, and I'm happy to. The answer is yes. Historically and in the past 10 years, really, primarily we've dealt with Canadian banks, and Canadian, the equity and certain capital raises, everything came from Canada. We are starting to see, and I'd say really only in like the last year or two, you're starting to see, of course, VCs and some of these different groups in the United States wanting to actually invest and wanting to be part of everything that Canada's sort of been participating in. So it's good in the sense that it's a lot less complicated, obviously, when we have international issues and we've got to deal with securities regulations from a US and Canadian perspective, but it's challenging in that most US financial institutions, especially from a traditional aspect, are still trying to fit, a square peg in a round hole. So I can always tell when I've got a new lender who comes in and goes, yes, we lend in the cannabis space. And then I get their due diligence packet and I'm like, okay, let's back up. Let's work through exactly how this works. Because again, in a lot of state programs, you can't use the license as collateral. There are different rules and regulations and restrictions as to who can, even from a real estate perspective, I can't just lock a tenant out for not paying and take their product. There's so many complications. I could go on for hours that it's challenging. And so they're trying, we're getting there. It's still hard. Most traditional banks still will not do it. You've got some more community style banks that are trying to lend. Again, we work with a lot of them to figure out what their due diligence looks like, what they actually secure. And there's just, from a banking perspective, they're, not folks that are usually risk adverse. So it can be a challenging conversation, but I will say that especially in the last year or two, we've seen a significant shift in the attitude. They're trying, but it's a process, because now you're looking at $40-60 million capital raises, and they're just not quite equipped. It's not an easy process, but there has definitely been movement. And so I absolutely think that will continue.
The only thing I'll add to that is I will note that the state chartered banks and credit unions tend to be a little bit more friendly than those nationally chartered ones. I am interested in how that looks in Vermont, just because I know from working at DFR, Vermont has such a robust local state bank ecosystem. But the one thing I'll note is, because of the somewhat lack of availability of that banking financing, whether it's because of its cannabis itself, or because small business loans just aren't that easy to get, we are seeing those VC or those more private equity deals or loan deals, and we're seeing actually a lot of what we would describe as predatory practices, where folks are really, they're like, we've got the capital you need, so here are these really draconian terms. And so it's interesting, because you have to ask, as regulators, how far into that can we get? How much of that is actually within our jurisdiction? But it's not something we love to see in the industry. So just an interesting wrinkle that is created by that issue.
Yeah, I've referred to that as like the cannabis tax from a real estate, perspective, how certain, landlords kind of treat or think about, cannabis generally. I can say to your first kind of, question, Christopher, I guess wasn't a question, more of just a thought. We do have relationships with some of the state-backed credit unions in Vermont. They're willing to lend. We're in this chicken and the egg kind of situation, because we wrote our rules saying you need a bank account in order to get a license. And of course, banks want to see a license before they want to give the bank account. So we developed this pre-qualification process where you can kind of go through your background check stuff, show that you're a well-qualified applicant to take to a state chartered bank. And there is a couple in the state willing to work with folks. Fees are not great. Fees are not friendly. Some take a flat fee, some take a percentage off what you're expected to make. It's certainly an issue, and it's an ever evolving conversation with those banks and trying to figure out a path forward for especially some of our smaller growers. I mean, if you look at the tiering structure from a cultivator perspective that we have in Vermont, I'd say half of the 6 tiers that we have would be considered micro licenses in other states. We do have a hand up. Rooney, I see your hands up, so feel free to unmute yourself and tell us who you are and ask your question.
Hello, what's going on? Rooney JD, class of 2015. Hello, Kyle and Chris, long time no talk. Happy to see y'all are making big moves in the industry. So this question kind of goes out to all 3 of y'all on the panel. What would you say is the one biggest issue that you guys were completely blindsided by while developing this regulation? Like, whoa, I would never have anticipated that this would have been a problem.
I think we're all looking at each other like, who wants to go first?
I guess the one thing I'll note, and this isn't really from a regulatory perspective, but I was surprised initially by how other state agencies, when we first started, were a little like, how do we deal with this, right? So because as Kyle indicated, the emerging cannabis sector touches almost everything. And so we're not the only regulator that they have to deal with. And so seeing how tentative some of the other state agencies were or are, especially given federal prohibition still, I think that surprised me, because in my mind, the legislature had spoken, right, and created this, or the people had spoken if it was a ballot initiative, but this is law now. And so to see kind of how tentative and somewhat nervous other state agency appeared to be, they've come a long way, and we found ways to work with them, obviously, but that was a little bit of a surprise to me.
Go ahead, Laura.
No, it's okay. Go ahead, Kyle.
I was just going to say, I completely agree. I came from the Agency of Agriculture. I view this as a plant growing out of the ground, but in Vermont, it's not considered agriculture. It's considered a commercial product. And agriculture in Vermont, if folks have studied this while in Vermont, Vermont enjoys 80 something odd exemptions from land use planning law. And so for me, especially from an outdoor cultivator context, getting folks used to having to go through conversations with their municipality, potential Act 250 issues, all of these other issues that, folks that want to make this a part of their diversified operation are putting their other operations at risk, depending on if they're, seeking any assistance from the federal government. There's just, the ball of yarn gets more knotted the harder you yank on it. And I think, just taking it methodically day by day sometimes, helps prevent you from banging your head against the wall, trying to help present a path forward for small folks with limited access to capital that cannot afford to get bogged down in how state government typically operates.
Yeah, and I laugh because I feel like on a weekly basis, there's something that I'm like, okay, thought we saw it all. Just kidding. There's constantly surprises, but for me, honestly, it was in the beginning, and when we first started working in the cannabis sector, State Bar Association. I received letters that said, we're not sure that we'll keep your license in force. It could be revoked. You're violating federal law, and it's changed significantly since then, but I remember thinking, this is something Arizona voters passed. It's completely unknown. We don't have case precedent. What other area would you need a lawyer even more so to help you really navigate and figure this out? And so, we made the decision to keep going forward and do it, but it's certainly, especially as a young lawyer, it's definitely scary to go. I just went through all of this. This is a state law that people want a lawyer, want to hire me for, and the state bar going, yeah, I don't know if you're going to keep your license. So that probably still remains the biggest, the biggest shock. Thankfully, we got past it.
Absolutely. Well, we're just a little bit behind schedule. Somehow we fit a lot of content into an hour, but I'm going to turn it back over to Rick to close this out.
Great. Thanks, Kyle. And I wanted to thank the panel for presenting here today. And thank everyone who joined us. This event was produced by the VLS Alumni Association Alumni Engagement Committee. And we welcome anyone that's interested to reach out, and we're happy to get you involved. This webcast was part of the committee's effort to provide opportunities for VLS alumni to connect throughout the country and the world. We think that VLS is a great institution, and we hope you agree and will consider joining the VLSAA board and making a gift to the school. It doesn't have to be a large gift. We follow what's called the United Way model, which is it doesn't matter how much you give, but that you give. It helps the school with rankings and grants and a whole host of other things to get our giving percentage up. So I would encourage everyone to take a look at the post-event survey and click on the give link to give a gift to the school. Lastly, I'd ask you to keep an eye out for the next in this series. It's scheduled for June 2nd at 4 p.m. Eastern. It will be more of a granular dive into this emerging industry. We'll focus on things like marketing, some other business related issues, some of which were touched on this afternoon. Finally, on Friday, June 24th, during reunion, a CLE will be presented, which has been qualified for ethics credit. So if you are attending reunion or just want to get back to Vermont and go see a cannabis CLE, you're welcome to join us. We look forward to seeing you at the next event, and registration should be opening soon, and keep an eye out for that email. That's all for this afternoon, and wanted to thank everybody for participating today. It's been a great event, and again, thank the panelists, and also like to thank Andy, Laura, and Brock back in South Royalton, who are helped making this possible, and we couldn't do it without them. So thank you, everyone.